Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why TrustArc built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
This is Serious Privacy by TrustArc. Here are your hosts, Paul Breitbart and Kay Royal.
For many people, cookie banners are one of the biggest frustrations when surfing online. Most people just click I accept to get rid of the banners. Others continue looking for a decline all button. And those who actually go into the setting in recent years will have noticed that the banner has become more granular, but also more confusing. Next to the consent options, suddenly legitimate interest options appeared, and it became less and less clear what cookies would be set in which situation. A long-awaited decision of the Belgian Data Protection Authority on February 2nd, 2022, will probably bring some relief. The complex cookie banner, which is driven by the Transparency and Control Framework of the Interactive Advertising Bureau, has been found not to comply with the GDPR on multiple fronts. Our guests today, Charlotte Recker and Julian Dekkers, both work as legal advisor for the litigation chamber of the Belgian DPA and are happy to provide more insights into the decision against IAB. My name is Paul Breitbart.
And I'm Kay Royal, and welcome to Serious Privacy. So I'm absolutely delighted to have y'all two on here. Actually, I'm waiting for the day I have a guest when I go, I don't want you on my podcast. That's never happened. That's never happened.
Maybe
we have
that's
fabulous people on here.
That's because we have control over the guests, Kate.
Might be.
Probably just a little, right? Okay, so apparently I have a snarly chihuahua with me today, so if y'all hear growling, that's where it's coming from. But let's make that the unexpected question then. If you had to be an animal, what animal would you choose?
Wow, maybe I'd be a water animal, maybe a dolphin to roam freely through the oceans. Yes, that sounds good.
Love it. A dolphin. Oh, that just makes you think of all nice, quiet oceans and water. And
good weather.
Nice. Yes.
So, Julian, how about you?
Looking at the fact my mother has 2 Jack Russells and she really spoils them, I'd say I'd be Jack Russell. Because usually those are very spoiled dogs that happen to run in the outside anytime they like. So, yeah, that would be my answer.
Full of energy. Yep. Full
Sounds
of energy.
Good.
Love it. All right, Paul.
I think I'd be a blackbird. Just a blackbird. Just being outside, flying around a bit, just being in the forest and being able to sing very beautifully.
Oh, that sounds poetic.
I like that. You're like her. You're looking for the freedom of movement and being away from everything that's us. I think I'm going to be a little bit more like Julian and say I'd be a cat.
Just sitting in the corner, observation, everything that's going on.
Yes, a spoiled, rotten indoor cat. That's what I would be. I can't go with the Jack Russell because of this snarly chihuahua right here that you're going to hear from on the podcast. All right, so Paul, over to you. First questions.
First of all, thank you very much again for joining us. You've been involved in the decision of the litigation chamber against IAB Europe on the Transparency and Control Framework. What, in your view, is the most important part of this decision?
I think the most important part is really about the fact that the TCF, so the Transparency and Consent Framework, which has been developed by IAB Europe, defendant in this case, has been deemed not compliant with the GDPR in regard of many aspects, but the most important one being transparency towards the users, I think. Mm-hmm. And of course, the impact of this decision is huge due to the popularity of the framework. So this framework is being used by many websites in the EU. And so, of course, given the observation that the litigation chamber made regarding the compliance, it does have impact not only on IB Europe, but also on other actors that are using or relying on the TCF for their websites or applications.
So for those of our listeners who don't completely understand or are not familiar with the Belgian DPA's approach to investigations and enforcement decisions, you work in separate phases, right? First the inspection, and then the litigation chamber takes over for the enforcement part or for the sanctions part.
Well, not only. So one of the elements on which the litigation chamber bases itself to take its decision is the report produced by the inspection service. However, it's not the only element which we base ourselves on, and we're completely independent from the inspection service. We also take into account external information. But that's certainly one of the pieces we rely upon.
Okay, very good. And what struck me most probably in the decision, of course, the expectation was already for a long time between privacy professionals that the transparency and consent framework would be found non-compliant with the GDPR because of the legitimate interest part. But you've gone much beyond just pointing towards legitimate interest and actually, well, maybe this is too much of a word, but you basically tore apart the whole...
Well, that's not entirely the case, because we did not completely ban the TCF as a framework. So that's, I think, another key aspect of this decision, that we base our assessment on the current version of the TCF, so the current policies that are being implemented by IB Europe and that are enforced on the organizations. So we did not completely ban it, because we think it is still important for users to be informed of what happens with their data, what they consent to, so what happens when they go on a website or an application. And that part, we could not completely dismiss it or completely ban it and revert back to the previous situation where there was no transparency and consent framework at all, and it just happened behind the curtains completely. So I think, yeah, we did see that there were major flaws with the TCF, the main one being the absence of any legal ground for the processing of the preferences themselves, so which are captured in a so-called TC string, and this encapsulation is entirely defined and developed by IB Europe.
And imposed upon.
So that's the first aspect, that the fact that the preferences of the users are processed without any legal ground to do so. And in that regard, the defendant did not agree with the fact that those preferences were personal data of the users, but we did find that it was indeed personal data, because the purpose of the TCF and the TC string is really to identify the preferences of a single user in order to be able to determine whether you can or not process their data.
So which would then allow to single them out of a group as the GDPR defines it.
And also there's a moment where the user is actually identifiable. When the CMP places the cookie, it's able to read the IP address
of the device, indeed. Yeah.
So one of the things that surprised me probably is that you also consider IAB Europe to be a data controller. Can you explain a bit why that is the case, and also what consequences that might have for other organizations acting as a service provider in similar settings?
Well, we saw, based on the inspection reports and also on based on the arguments that were provided by IB Europe during the hearing, that they do define certain characteristics or certain aspects of the processing of the TC string itself. So first of all, they define how the TC string looks like. So what does it contain? What information does it contain? How the CMPs, so the consent management platforms, are supposed to treat the preferences, where they are supposed to store them.
How long?
For how long they must keep them, because IB Europe also defines itself as a managing organization with regard to the TCF itself, and so with regard to the processing that happens within the TCF. And as a managing organization, they also require the participating organizations, being in most cases the CMPs, the consent management platforms, to keep records of consent and be able to provide those records to IB Europe as soon as they ask for it. So there are many elements that we consider as essential means for the processing that are defined by IB Europe and imposed on the participants. And in addition, the purpose of the TCF is defined by IB Europe as a means for ensuring compliance when organizations decide to process data based on the OpenRTB protocol, for example. Mm-hmm. And so it's really this combination of defining the purposes and defining the means of the processing that render, in our view, IB Europe as a data controller.
Mm-hmm. And in practice, they impose these decisions on the participating organizations through their policies, and their technical specifications.
It's great how you explained why you consider that IAB is a data controller. Do you think that this decision will also set a precedent for other organizations, that they should start considering seeing themselves as a data controller instead of just being a data processor?
Well, we did had some brainstorming regarding the comparison that some other people made between IAB and certification bodies or other organizations that indeed develop standards and then have those standards being used by other organizations. And
that's fascinating.
But we really found that there were some differences between IAB Europe and, for example, an ISO organization or the ISACA organization, I think, because contrary to those organizations, IAB Europe really not only develops the framework and the policies, documentation, etc., but they also enforce them on the participants, and they also have this management organization role that they take, which in our view makes it very different from other certification bodies who would just either control the implementation by other companies without defining the standard themselves, or they would only develop the standard but then be done with it and not be the ones that will either implement it or enforce it or control the compliance with that framework.
You know, when I read your decision, I think it was either a blog or an internal advisory. I advised that this might be something that customers need to pay a closer attention to as to their decision making over the data, which for a long time I have always said that it's interesting that a lot of cloud providers are chosen because of their expertise. So to say that they're following the instructions of a controller is a little bit of a false construct. But, you know, I didn't really think about it in terms of them being a certifying body, because in that respect, TrustArc is a certifying body when it comes to our own certifications that we do, whether it's the Privacy Shield certification or it's our own certifications that we do for enterprise privacy or international transfer, or the Apex CBPRs that we're a certifying body. We're absolutely the controller. And we push back on companies that are saying, how can you possibly be the controller when this is our data? I'm like, because we're an independent third party. We're an independent third party, so we have to be the controller because we can't do as you instruct us to do, or how could our findings possibly be independent? So with that logic, Julian, I think I agree with you. Up until now, I think I disagreed with you, but I think I agree with you now. I think you won me over on that
we read we could find in several doctrines articles that CMPs are often regarded as processors, but it actually really depends on a case-by-case basis.
So would you then also say that the organizations that implement the TCF on their website as part of their cookie banner, that they are joint controllers with the IAB, also requiring a joint control agreement, or would that be a controller-to-controller transmission?
Well, on that aspect, as I just said, it depends on the case-by-case implementations, because the TCF is a very complex landscape and which offers various possibilities of implementation. So as we try to nuance a bit in our decision, in some cases, and some authors have highlighted this issue, some CMPs, for example, decide not to offer to website publishers the possibility to add an opt-all or reject-all button, for example, in the interface. And that is often the case with smaller players, smaller website owners, which then would not have this due diligence of still negotiating with the CMPs to still add that button. And so it really depends on the case, but some CMPs do define, for example, the list of vendors that are presented by default and sometimes ticked on by default based on the legitimate interest. And by doing so, they do define the recipients of the data, which is considered as an essential means of...
So yeah, this is certainly something for everybody who has implemented the TCF. Don't wait until the IAB comes with further guidance 2 months down the road on how they are going to change their framework in order to comply with the Belgian decision, but also start doing your own homework right now to make sure you are compliant as well, because it could be indeed that you are a joint controller with IAB and that you will need to negotiate on top of everything else also a joint control agreement, or that you need other legal documentation, other forms of contract to make sure that the whole flows are legal, that are taking place via your cookie banner.
Precisely.
Right.
So one of the things you just mentioned a few minutes ago is that IB is also working on the open RTB standard, I think you called it, the real-time bidding. So basically auctioning my data in order to be able to show me an advertisement. Until a few years ago, I had not even heard of RTB. I never knew it was a thing. My former colleague, Rob van Eyck, who is now with the Future of Privacy Forum, he did his PhD on that particular issue and eluded me into this whole scary world.
That you wish you never heard of?
Yes, that I wish I never heard of, but apparently it's still a thing. Can you talk a bit more about how this falls together with the TCF and what the litigation chamber of the Belgian DPA said about it?
Right, okay, yeah, we're absolutely aware of Rob van Eyck thesis, which is indeed very... well, interesting. So just to connect the dots a bit, maybe I should start by giving a short explanation of what the OpenRTB standard is.
Yes, please.
And then explain what the link with the TCF is. So the OpenRTB protocol is, along with the authorized buyers of Google, one of the most used protocols for what we call real-time bidding, which is actually the instantaneous automated online auction of users' profiles for the purpose of buying and selling advertising space on website or applications. So concretely, when a user goes on a website for the first time, a pop-up appears. That's the interface provided by the CMP. In that one, he can consent or object to the collection and sharing of his personal data. Now, this is where the TCF, so it facilitates websites and applications which are participating in the TCF to capture, through the CMP's interface, the user's preferences. So these preferences are stored in what we call the TC string. And this TC string is then shared with the organization participating in the OpenRTB. I don't know if I've been very clear.
I can still follow.
It happens faster than instantaneously, right?
Half a second.
Yeah, so it's not like an auction house where they're sending it out and you can wait 5 minutes for someone to respond and say, yes, we want to bid on that one. This is
the auctions I'm involved in now, they take a week.
Even think it.
Yeah.
Yeah, in half a second, millions of advertising spaces are sold, so it really goes very fast.
Half a second.
Wow.
Yeah.
Or less, yeah.
That's really fast.
Well, and then for guidance, and Paul, please forgive me if you were about to jump in with another question, but you were talking about guidance for the companies that are following this decision, especially those that are using the real-time bidding in the controller relationship, what they might need to negotiate. I'll be honest, I'm not really sure what companies should do now if there's a possibility. I mean, I know they should get rid of the data they've collected under it because it's illegal data at this point. I don't know how much faith y'all have in the controllers, the companies actually dumping the data. That would be interesting to follow up on. But what should they be doing if there's a plan possibly that they're going to come back with and maybe their platform can continue and there's going to be some sort of transition, kind of like this mythical privacy shield we keep hearing about. At some point there may be a plan and there may be a transition. What do y'all, and Anne Charlotte, I'll come to you with this, what do y'all recommend that companies, especially the ones using the real-time bidding?
Well, if you're referring directly to IB's to come plan for action, that we can't really say much because we'll just have to wait, see what proposals they submit.
Oh.
Is that not
Obviously.
what you wanted to hear? But in general, for organizations participating in the TCF, we just say, try and be really careful, check if you're compliant with all the various criteria of the GDP. I think that would be the safest option, thinking by themselves and making sure that they're compliant by themselves and checking everything.
Don't just trust, but verify actually that everything you do with cookies on your website is compliant. And then we are not talking about the data transfers. That's a whole different issue, but just the basic GDPR compliance and e-privacy compliance, because it all comes together.
Precisely.
Right, and the e-privacy wasn't mentioned in the decision, right?
Well, it wasn't mentioned because it wasn't only the placement of a cookie. It was really the entire processing that goes behind it or after the placement and
Right.
the capture of the preferences placed as a EU consent v2 cookie on the user's devices. So we didn't want to put too much focus on the e-privacy aspect because it's also what happens next. So the processing that occurs or the impact of the TCF on the processing occurring based on the OpenRTB protocol, basically.
So very much a deliberate decision to avoid letting people sink into putting this into an e-privacy directive decision.
There is, of course, a clear link with e-privacy, but we didn't want to put too much emphasis on that part.
Okay, I like that.
So this is yet another decision that had to go through the European Data Protection Board for consideration because it has a significant cross-border effect. But this time, contrary to, for example, the decisions we saw in the past about Twitter and Facebook, we did not see a very big discussion, at least not a very big public discussion in the European Data Protection Board. Is there broad support from the other data protection authorities for this approach, or was there still some discussion where feedback from other DPAs led to changes in your final decision?
Great question.
We did get some comments, but mainly we got two reasoned and relevant objections. Which then led us to make some changes in the revised draft decision, yes.
But there was no need to go to the Article 65, the dispute resolution mechanism. You were fine with the objections that you received and were able to address those?
Absolutely. So we did have also various discussions with the other authorities. As soon as we've published the draft decision on IMI, we did invite the other authorities to come to us with any questions or just to streamline the whole process as much as possible. And so we did receive a few comments from authorities that maybe did not have any reasoned objection, but did have some comments to improve sometimes the readability of the decision or to clarify some aspects. But we did receive, as Charlotte said, two reasoned objections from two authorities, which were taken into account because they were relevant for the decision. So those were taken into account, and we did not receive any further objections after we submitted the revised draft decision.
Well, that's great to hear.
And please forgive the American over here, but with that being the process, then this means there's not likely a high possibility of an appeal.
There is, because, well, the appeal is on a national level. So after that, the final decision has been published and uploaded into the IMI system. So that's a platform for exchange between the SAs in Europe. Then it becomes a wholly national procedure, and the parties might launch an appeal against the decision.
Indeed, yeah. So the Belgian DPA is acting as lead supervisory authority in this case. So any appeal will be brought against the Brussels Market Court, so which is the Court of Appeal from our decisions. And so the both parties have 30 days starting from the notification of the decision to appeal the decision.
And given the public stance of the IAB Europe so far, I would expect them to appeal and not just to say, okay, well, we've tried our best and now we're going to change it. But obviously you are not able to comment on that yet. which is completely fair. But say that there would not be an appeal. What is next in your mind? Would you indeed expect the IAB to send you a letter 2 months from now with these are the changes that we are going to implement, and will those be reviewed and approved, or is it just that they need to notify the changes that they make? How does that work?
I thought that was a very interesting approach.
Well, yes, now they have 2 months to submit a proposal, a plan of action, and that one will indeed be reviewed by the Belgian Data Protection Authority, and then we'll see further.
Yeah,
and does that go back to the inspection services, or is that the litigation chamber that would do that?
That is something we cannot comment on right now. But the intention is indeed once the action plan gets an approval, they would obtain 6 months to implement the approved measures.
Yeah, with daily financial penalties if they don't comply.
Oh, nice.
But if I hear your timeline correctly, say there is no appeal, then IAB has 2 months to present their alternative to the Belgian DPA, and then they will be given up to 6 months, but with daily financial penalties to roll it. So it might mean that we are still waiting until the end of the year before a new transparency and consent framework is fully up and running. What should happen in the interim? Are all the old, non-compliant banners, should they go offline immediately? Or is there also that same grace period between parentheses for those banners?
Well, I wouldn't necessarily put it as a grace period, because of course the infringements are, the ones that we've identified are still very real. So our advice would be to website publishers to indeed, as we said earlier, to review all the vendors that are presented currently on their website and just make that assessment. Do they actually need all those vendors to be present on the website? Also identify which vendors are located maybe outside of the EU. And so we think that the due diligence is still effective and still needs to be applied by all the parties involved in the TCF as of right now, of course.
And what about companies like TrustArc that offer the cookie consent banner? And they may have customers who are using the IAB TCF.
Well, again, it's a very difficult question for us to answer, because it depends on the case by case. So how is it currently being implemented on the website or in the application of the public? What were the instructions given? What were the possibilities offered to the publishers to maybe have a say on the list of vendors or the interface that is presented to data subjects? So it's really a joint operation in that sense between the CMPs and the publishers, just to make sure jointly that the current configuration is indeed compliant with the GDPR.
Basically, go do your homework.
Okay.
Indeed.
And go do it right this time.
Absolutely. Well, I think that is a great note to end upon. Thank you so much, Julian and Anne-Charlotte, for being with us today and explaining this decision. As said, it's been long awaited. It gives all of us in the privacy community a lot to think about, a lot of homework. So thank you very much for being with us this week. And thanks to all our listeners for listening to yet another episode of Serious Privacy. If you like our series, please do tell your friends and colleagues about us. Rate and review our episodes in your favorite podcast app or on your favorite podcast platform. And should you have any questions or suggestions, please reach out to us via seriousprivacy@trustarc.com or info@seriousprivacy.eu, via Twitter at @podcastprivacy, or via LinkedIn. Just look for Serious Privacy and you'll find our page. You'll find Kay on Twitter as...
Absolutely, even though I am unemployed
Well,
right
that's just
now.
for another day. You will find Kay on Twitter as Heart of Privacy and myself as Euro Paul B. Until next week, goodbye.
Thanks for having us. Bye.
Bye, y'all.
Thanks, Bye.
That was Serious Privacy.
If you're a data protection or privacy professional, you already know the pressure. Non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No, that's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace, so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data, and get credible, cited answers based on NIMBY research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, create a cookie banner, or start an assessment, quick actions take formally complex tasks, turn them into bite-sized guided workflows to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore Arc at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.